let me begin by saying that I'm not a First Amendment scholar, and I'm not a regular participant in ICANN policy. I'm a humble law professor, and I've come all the way here just for this session and just with one simple message, and that is that trademarks and domain names are distinctly different animals. So policy that works for trademarks doesn't necessarily work for domain names. And this is my chief concern with the draft report. It may be, this caused me to think that it may be that trademark law is a little bit different from other areas of intellectual property law in that it's not so easy to tweak trademark law into the digital age, the way we've seen this being done with copyright law and patent law. I think trademark law looks very flexible and accommodating, but that is quite deceptive. Trademark law, probably chief amongst all the areas of intellectual property law, is very finely balanced, and it can be set off kilter quite easily. And I think this policy would really do that. So what I have to do is, in the next couple of minutes, give you Trademark Law 101. But I promise you it's not boring. It's really rather interesting. So, I can identify three large distinctions that need to be made between trademarks and domain names. Trademark law is really focused on territories. It seems strange in this age to be focused on territories, but it is. And even though we have now quite developed international trademark law, that law still respects that fundamental principle, that trademark law is territorially based. So that even in international trademark law, these territorial rights and concepts are respected, right? So we regulate trademarks because they have a significance within a region. That region may be the state, that may be a smaller region within the state, that may be in a particular niche market within a state, but that's the extent to which the rights extend, right? The rights do not extend beyond that. In order to have trademark rights from one state to the next, you need to do something to acquire those rights, right? But the virtue of having a trademark does not grant rights internationally. And that, I think, is something to remember here. When we start to elevate these trademark concepts and policies to domain name policy, we cross a very big threshold, because then we grant these trademark rights internationally, something that international trademark law has never done. Trademark law is always focused on the consumer, right? We justify trademark protections because we're seeking to protect consumers from commercial deception. But all of the rights in trademark law, all of the doctrines, all of the tests in the law are focused on the consumer. The law always asks, who is the relevant consumer for this mark? What do they know? What do they think? What would they see when they see this second use of the mark? Would they be confused? So it always considers the relevant consumer, and again, that's geographically based. It may be market-based. And it would be impossible to consider an international, generic, universal consumer, right? It would be impossible to ascribe knowledge, sophistication, attributes to a universal consumer. What would they take? Because as you know, when you travel, you take different information with you. You perceive things differently from place to place. Finally, all trademark rights are considered in context. In fact, trademark owners have fewer rights than you'd imagine, right? They don't own the trademarks in any real sense. They have limited exclusive rights against others, only in situations in which another would cause confusion of the relevant consumer. That's the only case in which a trademark owner can assert their rights against someone else. So we have to look at those particular contexts of use by third parties to see whether the relevant consumer would be confused. We don't just look at the words, we look at the market situation. How are they displayed? What other information is on the label? What other information is in the buying experience? What kind of a product is it being used on? We looked at all of these things to determine whether or not a consumer would be confused. So it's highly contextual. It's not abstract. It's not in theory. And these are a very limited set of rights. So, to take these ideas and apply them to some of the recommendations, I want to begin by looking at recommendation 2, which says, strings must not be confusingly similar to an existing top-level domain. Now that confusingly similar is a trademark concept that's being used. But it's used here with an incorrect understanding that that is the trademark test of infringement, confusing similarity. It is not. It's the first step toward an analysis of infringement. It's the first step that we take when we consider whether the trademark owner has a prior right. We look at that as we look at the two words. Of course, trademarks are not only words, they're all kinds of things now, but we look at the two words and we see whether the identity is so close that we would say they were confusingly similar. But as I've just said, the analysis goes much beyond that. We look at the kind of consumer that would buy this kind of a good. How sophisticated are they? How much care do they take in this buying decision? How is this being marketed? Let's look at the media uses. What's on the shelf next to it? We look at all kinds of contextual things so that words that we may initially determine to be confusingly similar may not be an infringement. That is, they're not likely to cause confusion. And that's why we allow many parties to use the same words as trademarks, as legally protected trademarks, right? And I give the example of Delta, right? There's Delta Airlines, there's Delta Faucets, there's Delta Dental, and probably numerous others. If you do any search of a trademark in any database of any country, you'll find numerous parties registering the same terms because they're used in different contexts. They may be confusingly similar, but they're allowed to be used. I guess I just want to add one more point here. The idea of making a international right in a trademark has never come to fruition in the history of trademark law and the history of international trademark law. The closest we've come to attempt that kind of thing has been in the protection of what's called geographic indications, and this is a source of international debate presently. That is, should the word cognac be reserved against all other uses internationally? You can imagine some countries would favor that policy. But international law does not protect that idea because it recognizes that cognac may mean something in France, but it may mean something entirely different to consumers in the United States who may regard that term as indicating a fine brandy, but not necessarily a product of a particular region. And so we allow those kinds of terms to be used, and we allow the governments of different countries to regulate their use. There was an attempt to have a kind of universal protection for these terms, but that is not the case. Okay, recommendation 3 says, strings must not infringe the existing legal rights of others that are recognized or enforceable under generally accepted and internationally recognized principles of law. Well, let me tell you that everything that you can think of is protected as a trademark. I would challenge you to come up to me afterward and give me a name, a word that is not protected as a trademark. Even some of the words that have been discussed as possible good candidates for new top-level domains are protected as trademarks. We are sitting in the Hilton Hotel. I guess earlier there was a conversation about city names like Paris being a good candidate for a new top-level domain. I can tell you that there is somebody who has registered the word Paris connected with the Hilton hotel chain and family. So really, And I'll also say that once a policy like this is really not draft, but final, there will be a situation of trademark squatting. So if by chance there's not the word books registered as a trademark, there will be. Because in most countries of the world, it's very easy to get a trademark registration. You don't have to necessarily be using the trademark in commerce. Very few countries like the United States have any kind of restrictions like this. It's very easy and in some cases cheap and quick to get a trademark registration. So my guess is that there are numerous trademark registrations for the word book, but if there aren't, there will be. And I think this is really an unworkable standard. And when you think about it, the fact that someone has registered the word Cherokee already, and in fact numerous commercial entities have registered the word Cherokee. Why is it that we would consider these parties to have important prior rights that we would want to respect? If, for instance, the Cherokee Nation thought it would be a good idea to have Cherokee as a top-level domain. All right, now to the thing that, and one other point. Since I'm so focused on the idea that trademark law really doesn't track good domain name policy, I haven't been focused on the fact that there are all kinds of defenses and limitations in trademark law that would need to be taken into account. And one such limitation is the fair use doctrine, which says if a trademark owner has captured a descriptive word as a trademark, they don't have the right to exclude other competitors who would want to use that word in commerce with a use that is not a trademark use. So that doctrine alone would allow top-level domains, which are inherently not trademark uses, to exist, even where they would be confusingly similar to words that people own as trademarks. All right, recommendation 6 about the public morality and public order. I can understand why the committee would have been thrilled to see that international trademark law does address this idea that there could be some regulation of immoral words. But I think there's a misunderstanding of what international trademark law does here. We have a very recent and huge international trademark treaty, and that is the WTO's TRIPS agreement. This is the newest multilateral agreement on trademark law. It doesn't mention this. It certainly was a possibility to include, but the TRIPS agreement does not include this provision. The Paris Convention does include a provision relating to this kind of restriction, but it's important to note that this is not a minimum standard. It is not a minimum standard that countries must regulate immoral words as trademarks. The Paris Convention merely permits countries, if they so wish, to make a kind of regulation restricting words as trademark registrations. The next point, and the United States is one of those countries that has some kind of legislation restricting immoral words as trademarks. But it's very important to note that this is not a restriction on use of a trademark, and this is not even a restriction on legal protection of a trademark, which could be deemed to be immoral or scandalous as the Trademark Act mentions. This is only about federal registration as a trademark. So if you wish to adopt an immoral word or a scandalous word in the United States as a trademark, you may be prohibited from federal registration. You may not be prohibited from using that word or from deriving legal protection through federal common law, which is built into the Trademark Act, over the word. So it's not as grand a restriction as you might think from the committee report. And it's really little used. And again, this restriction is used in context. So words that would appear to be scandalous or immoral, in many cases, in decisions, the court has said, well, when we look at the context of the use of this word as a trademark, when we look at the marketing materials, when we look at the label of the goods, we see that it's really a double entendre and it's not really scandalous. So we don't take the word alone, even under that doctrine. It's in context. And it's important to note that even though this provision exists in U.S. law, by and large, it's only utilized by third parties who are raising objections. It's not something in which the trademark office is asserting the standard against would-be trademark registrants. And that's all I have to say. Thank you.